Building upon the previous discussion of HOA disclosure requirements in Arizona, this section focuses specifically on the seller's legal obligation to disclose enforcement actions, liens, and membership details related to a property located within a planned community. These disclosures form a vital part of transparency in real estate transactions, ensuring that buyers are not surprised by hidden financial liabilities or unresolved compliance issues after closing. Arizona law provides a clear framework to guide sellers in what must be disclosed and when, helping protect both parties from future disputes. Under ARS, Paragraph 33, Chapter 16 of the Arizona Planned Community Act, a seller of property within an HOA-governed community must disclose any known enforcement actions, outstanding liens, and details of association membership to the buyer. These disclosures are required in addition to the HOA's standard document package, which includes CC&Rs, bylaws, and assessment information. The purpose of this specific requirement is to ensure the buyer understands the property's standing within the association and any legal or financial issues that could affect ownership. 1. Enforcement actions. An enforcement action refers to any ongoing or pending violation of the association's governing documents, such as the CC&Rs, rules, or design guidelines. Sellers must disclose if the HOA has issued notices of violation or is pursuing enforcement measures against the property. Examples include unapproved home modifications, landscaping violations, unpaid fines, or unauthorized short-term rentals. For instance, if a homeowner in the Las Sendas HOA in Mesa receives a violation notice for painting their home an unapproved color and has not yet resolved it, this issue must be disclosed to the buyer before closing. Failure to do so could result in legal consequences for non-disclosure, as the buyer may inherit the violation and potential fines. The Arizona Association of Realtors Seller Property Disclosure Statement, SPDS, provides a dedicated section for HOA information, where sellers must know whether the property is part of an association, identify any violations or notices received, and indicate if there are any pending fines or enforcement proceedings. 2. HOA liens and assessments. If a homeowner fails to pay regular assessments, special assessments, or fines, the HOA may place a lien against the property. Under ARS, Paragraph 33, 1807, HOA liens automatically attach to the property when assessments become delinquent and may lead to foreclosure if not paid. Sellers are required to disclose any existing liens or unpaid assessments before closing. For example, if a seller in Power Ranch owes $200 in unpaid HOA assessments, that balance must be disclosed to the buyer and resolved before the transaction closes. In most cases, escrow will require a paid assessment letter from the HOA verifying that all dues are current. However, the seller's failure to disclose prior liens could still expose them to liability after closing. Buyers rely on accurate information to budget for ongoing costs, and undisclosed liens could create unexpected financial burdens. The law ensures that the seller cannot transfer a property encumbered by hidden association debts or penalties without full disclosure and resolution. 3. Membership in the association. Membership in the HOA is automatic and mandatory for all property owners in a planned community. The seller must disclose that the property is subject to mandatory membership and the corresponding responsibilities, including payment of assessments and compliance with CC&Rs. This requirement ensures that buyers are fully aware that ownership includes both benefits and obligations tied to community membership. For example, a buyer purchasing a home in the Pecans in Queen Creek must be informed that membership in the HOA includes voting rights in board elections, but also requires payment of monthly assessments and adherence to architectural design standards. Such membership cannot be waived or separated from ownership of the property, as it runs with the land under Arizona law. Case example, Garden Lakes Community Association versus Madigan, 2004. In this case, the Arizona Court of Appeals upheld the HOA's right to enforce CC&R violations and collect fines after property transfer, emphasizing that enforcement actions and liens tied to a property survive ownership changes unless resolved prior to closing. The case reinforced the importance of seller disclosure, as buyers must be made aware of any unresolved association matters that may follow the property. Practical example. Imagine a seller in Verrado fails to disclose that the HOA issued a $500 fine for an unapproved pergola addition. After closing, the buyer receives notice of the unpaid fine, which the HOA expects them to pay. The buyer can pursue legal remedies against the seller for non-disclosure, and the broker may also face disciplinary review for failing to ensure full compliance with disclosure obligations. This example illustrates how proper disclosure not only protects buyers, but also prevents post-closing disputes and protects the reputation of real estate professionals. Discussion. Why is it important for sellers to disclose ongoing HOA enforcement actions to potential buyers? Answer. Because enforcement actions can carry unresolved fines or compliance obligations that transfer with the property, affecting the buyer's ownership experience. What must a seller disclose if their HOA has placed a lien on the property for unpaid assessments? Answer. The seller must disclose the lien's existence, the amount owed, and ensure resolution before closing, as liens remain attached to the property. Why must membership in an HOA be disclosed to a buyer? Answer. Because membership is mandatory, and it conveys both rights and responsibilities that directly affect the buyer's future ownership and financial obligations. Review summary. In Arizona, sellers and planned communities have a legal duty to disclose all known enforcement actions, liens, and details of association membership to prospective buyers. These disclosures, required under ARS Paragraph 33-1806A, ensure that buyers are aware of any ongoing violations, unpaid assessments, or restrictions that could impact property ownership. Enforcement actions must be clearly communicated, liens must be resolved or acknowledged, and mandatory membership must be disclosed as part of the transaction. Case law, such as Garden Lakes Community Association versus Madigan, reinforces the principle that association-related issues run with the land and must be addressed before transfer of title. Adhering to these disclosure standards upholds transparency, protects clients from post-closing disputes, and strengthens ethical practice across Arizona's real estate industry.